The liability, financial responsibility, and insurance issues surrounding the Deepwater Horizon are complex. There are estimates that suggest losses associated could result in between $1 billion and $3.5 billion in claims. Those will far exceed the liability caps that apply to offshore facilities with a limit of $75 million. If the predictions prove accurate, total damages will exceed the amount available in the liability trust fund. So this tragedy shows the need for a comprehensive review of liability concepts in the laws now in effect. When you look at the body of law, it goes back at least 150 plus years. Existing laws were developed from centuries of maritime history, as I learned back in my first term in Congress, as maritime is one of the oldest, most encrusted bodies of law in existence. The purpose then was to deal with damages to persons and property from accidents involving seagoing vessels. A vessel carries a known quantity of oil or other cargo. There's a reasonable basis for estimating the worst possible case of damages from release of all of the oil in the cargo of that vessel. This, in turn, establishes a basis for a liability cap and for setting levels of required insurance. One of the lessons of Torrey Canyon, of Amoco Cadiz, and other smaller spills, that there had to be, the insurance industry insisted on a known amount against which they could insure. In contrast, the Deepwater Horizon shows that when we're dealing with a facility for drilling rather than a merchant vessel, the amount of oil is unpredictable, unknown, and could be astronomical. Deepwater Horizon also demonstrates that the technology for drilling in deep waters and deeper regions below the sea floor is riskier and more uncertain than merchant vessel technology. It shows us that we need a financial and liability program based on the technological complexities and the realities of deep water drilling rather than simply adapting and adjusting concepts that were originally developed for surface vessels. In addition to the liability issues, the Deepwater Horizon tragedy shows that deep water drilling, complete reliance on industry, does not provide the safety margin nor the safety regime that we need. The federal government has allowed the drilling industry to self-police, self-certify, self-engineer and design, and it's time that we set new standards and exert authority over safety issues associated with deep sea oil drilling as we do with high-level aviation operations. The issues for consideration this hearing include raising or eliminating the cap on liability for both facilities and vessels, raising the levels required for demonstration of financial responsibility. A subsidiary issue of importance is whether any changes should be applied retroactively. And make no judgment on those. I want to hear the testimony that comes out of this hearing on whether caps and insurance requirements that exist and incorporated into existing leases, whether the government should be or would likely be in breach of contract, liable for damages if liability or insurance requirements were raised under existing leases. With regard to the liability caps for facilities, one option is to remove the caps altogether. A major argument against liability caps is that they reduce the incentives for operators to take steps necessary to ensure safety. In addition, liability caps that are well below the level of damages from a spill will mean persons who suffer damages will have to be reimbursed exclusively from the Oil Spill Liability Trust Fund, and if there are not enough there's not enough money in the trust fund, the injured persons either will not receive compensation or may be compensated by taxpayers from general revenues. The argument in support of liability caps is that without caps, only the largest companies will be willing to drill in the deep water. Only the largest companies will be able to run the risk of huge damages. And this could lead to less competition for drilling leases and lower proceeds to the federal government in selling the rights. Limiting drilling to the largest companies could result in less drilling and a reduced supply of oil. Somewhat different factors are involved when we consider raising or eliminating caps for vessels. For smaller vessels, tug barges carrying home heating oil are subject to a major increase in expense for insurance. There may be loss of shipping capacity that could have a detrimental effect on consumers. The potential damages from a spill from a vessel are more predictable than losses from an uncontained well. The amount of oil carried by a vessel is known. The amount of oil released by a spill such as Deepwater Horizon is speculative scientific guesswork. The caps for liabilities, for facilities rather, have not been adjusted since the Oil Pollution Act was enacted. And the caps for vessels have been raised by law and administrative action to adjust for inflation. So facilities have stayed unadjusted and vessel liability caps have increased. The Deepwater Horizon tragedy shows a need for a change in the trust fund that backs up the individual responsibility for damage. If the cost of cleaning up an oil spill and the cost of claims for damages from the spill exceed the limits in the Oil Pollution Act, the trust fund is available to cover the costs. The trust fund is funded predominantly by an 8-cent per barrel tax on crude oil at U.S. refinery, and the tax is paid by refinery operators. It now has a balance of about $1.6 billion with a cap on expenditures of $1 billion and $500 million for natural resource damages. We've passed legislation that raised the tax on crude oil to 34 cents a barrel and raised the caps on the trust fund expenditures to $5 billion. Still, Coast Guard tells us that they will run out of money to fight this disaster possibly next week because they will have exhausted the authority for the $100 million advance out of the trust fund. On May 13, 2010, just prior to our previous hearing, Transocean, the Swiss company, filed a complaint in federal court in Houston to limit its liability to $26.7 million under a little-known statute, the Limitation of Liability Act of 1851. The Department of Justice has since filed a motion opposing Transocean. The 1851 Act was put into place before ship owners had access to insurance to encourage American ship owners to invest in shipping and to put the American shipping industry on an even footing of competition with its European competitors. It allows ship owners to limit their liability to the value of the vessel and the value of her cargo. Claims for personal injury and death, for death and economic losses that are coming forward or will come forward will far exceed the value of the rig in the Gulf and whatever was owed to Transocean by BP and others. In researching the 1851 Act, which I recall from my earlier days on Merchant Marine and Fisheries Committee, we found in the Law of Admiralty book, Gilmore and Black, observation on that 1851 Act. No doubt, when more obscure statutes are drafted, the Congress will draft them. But it is difficult to believe that any future body of lawmakers will ever surpass this extraordinary effort. The only safe thing to do with such a statute is to repeal it. And maybe that's what we will wind up doing.